These news reports about what he was actually facing is not consistent with what the interaction was between the government and Mr. Swartz. A plea offer was made to him of 3 months before the indictment. This case could have been resolved with a plea of 3 months. After the indictment, an offer was made that he could plead and serve 4 months. Even after that, a plea offer was made of a range of from 0 to 6 months, that he would be able to argue for a probationary sentence. The government would be able to argue for up to a period of 6 months. There was never an intention for him to go to jail for longer than a 3, 4, potentially 5-month range. That was what the government said specifically to Mr. Swartz. Those offers were rejected.
And he committed suicide, correct?
He did.
The subscription service didn't support the prosecution. Does it strike you as odd that the government would indict someone for crimes that would carry penalties of up to 35 years in prison and $1 million fines, and then offer him a 3 or 4 month prison sentence?
Well, I think that's a good use of prosecutorial discretion to look at the conduct, regardless of what the statutory maximums were, and to fashion a sentence that was consistent with what the nature of the conduct was. And I think that what those prosecutors did in offering 3, 4, 0 to 6 was consistent with that conduct.
So you don't consider this a case of prosecutorial overreach or misconduct?
No, I don't look at what necessarily was charged as much as what was offered in terms of how the case might have been resolved.
Well, I would suggest to you, if you're an individual American citizen and you're looking at criminal charges being brought by the United States government with all of the vast resources available to the government, it strikes me as disproportionate and one that is basically being used inappropriately to try to bully someone into pleading guilty to something that strikes me as rather minor.